Thank you very much for the kind introduction, ladies and gentlemen. War and armed conflict profoundly disrupt the lives of children, if not putting them directly at risk of injury or death. This finding applies to all children involved in armed conflict, regardless of whether they live in the environment of a terrorist organization or in an attacking or defending state. It is typically the adults who instigate, organize, and direct such conflicts and acts of violence. In the most egregious cases, children are abused as instruments of war, utilized as human shields, or exploited as child soldiers. It is therefore unsurprising that the protection of children during and after armed conflict has been an important and enduring priority in international law for over a century. The Geneva Declaration on the Rights of the Child, adopted by the League of Nations Assembly on 26 September 1924, almost exactly 100 years ago, was a response to the devastating effects of First World War on children. The declaration contained 5 fundamental provisions for the protection and spiritual and material development of the child in post-conflict situations. It focused on combating hunger, disease, exploitation, and neglect of children in the aftermath of the war. The subsequent Declaration on the Rights of the Child, adopted by the UN General Assembly on 20 September 1959, expanded on these demands by setting out 10 basic guarantees. These included the right to a healthy and normal development, the right to social security, nutrition, housing, and medical care, the right to education, and the right to protection from neglect, cruelty, and exploitation. However, both declarations remained legally non-binding. Similarly, the draft agreement prepared in 1939 by the International Committee of the Red Cross and the International Union for Child Welfare, which dealt exclusively with the protection of children in armed conflict, was also devoid of legal force. The process of adopting a genuine agreement was superseded by the advent of the Second World War. It was only after the Second World War that regulations were adopted that placed greater emphasis on the legal protection of children in armed conflicts than before. The Geneva Conventions of 1949 and their additional protocols of 1977 marked the first turning point in this respect. In particular, Article 77, Paragraph 2 of Additional Protocol 1 and Article 4, Paragraph 3 of Additional Protocol 2 contain explicit rules on the protection of children in armed conflicts. Of even greater significance for the rights and protection of children is the 1989 Convention on the Rights of the Child, CRC. The CRC is the most ratified human rights treaty, 193 ratifications, and is the first human rights instrument ever to delineate the rights of children in a binding, comprehensive, and child-related manner. It has brought about a general change in international politics and social awareness. The CRC contains numerous provisions that evidence the role of children as bearers of their own rights. The child is no longer regarded as the exclusive object of protection, as was still the case with the non-binding declarations on the rights of the child of 1924 and 1959. Instead, the child is now regarded as an independent holder of human rights. The CRC is the sole universal human rights treaty that explicitly extends its regulations to armed conflict and establishes specific provisions on the rights and protection of children under these conditions in Article 38 CRC. Nevertheless, the norm brings with it some challenges that have not yet been fully resolved and which I will briefly outline today. First, Article 38, Paragraph 2 CRC, which establishes parameters for the ability of states to use children in hostilities, is a step backwards in the realm of international law. By setting a minimum age of 15 years, the norm takes over the rules of Article 77, paragraph 2 of Additional Protocol 1 to the Geneva Conventions. However, it deviates from Article 1 CRC, which defines a child as any human being below the age of 18. This divergence to the detriment of the child is particularly troubling, as it is made precisely regarding the life-threatening situation in armed conflict. The background to this dilution of the protective standard in the CRC can be attributed to the prevalence of countries in which children under the age of 18 constitute a large part of the population. During the drafting of the convention, several states expressed concern that establishing a minimum age of 18 would result in the exclusion of the largest pool of potential soldiers. They also argued that young people under the age of 18 are often more physically resilient than older persons. Indeed, children are utilized in hostilities mainly because they are easy to manipulate, do not question orders, and if their will is broken down by violence, threats, or the use of drugs, they can be transformed into fearless soldiers, readily capable of shooting at anything that moves. This approach during the drafting of the CRC is clearly child hostile. Therefore, during the drafting, several non-governmental organizations and state representatives expressed dissatisfaction with the relative low standard set out in Article 38, paragraph 2 CRC. They repeatedly stressed that the minimum age of 15 was inconsistent with the general age limit in Article 1 CRC and the overarching spirit of the Convention. Nevertheless, it took over a decade for this deficiency to be rectified by the first optional protocol to the CRC on the involvement of children in armed conflict, OPAC, which entered into force in 2002. The most important substantive change introduced by OPAC is the raising of the minimum age for direct participation in hostilities to 18 years. This has resulted in a certain degree of improvement in the legal situation in comparison to international humanitarian law, where the minimum age is still set at 15 years. Consequently, the CRC Committee, the treaty-based monitoring body of the Convention, urges states parties to advance the ratification and implementation of OPAC. In addition to this low age limit, Article 38, paragraph 2 CRC has other shortcomings. However, these have not been addressed by OPAC. Both treaties prohibit only the direct participation of children in hostilities. Although the initial polished draft of Article 38 CRC did not contain the word direct, it was added during the drafting process to align with the provisions and practices of international humanitarian law. Direct participation means that the child must be immediately used, engaged, or deployed in combat situations. Transporting arms and ammunition along the front line, transmitting military information, and acts of sabotage do therefore not constitute prohibited participation in hostilities. Nevertheless, it is evident that these acts can be as burdensome and dangerous for the child as direct participation in combat operations. The CRC Committee therefore rightly calls for a minimum age of 18 years for all forms of participation in armed conflict in its general recommendation on children in armed conflict. It underlines that in a situation of emergency, it is very difficult to draw the line between direct and indirect forms of participation. The distinction is often not clear-cut, but rather fluid. In other occasions, too, the CRC Committee has stressed the need to protect children who are only indirectly involved in hostilities. This approach is not only morally commendable, but also legally justifiable. Although the final removal of the directness requirement from Article 38, paragraph 2 CRC was not achieved during the drafting process, the rationality of the norm argues for a generous interpretation that includes certain indirect acts. For example, acts that disadvantage the adversary are to be qualified as direct participation if there is a certain temporal and geographical causality between the participation and the disadvantage to the enemy. This expansive interpretation is supported by the fact that Article 4, paragraph 3, letter C of Additional Protocol 2 to the Geneva Conventions prohibits the participation of children in all hostilities and does not distinguish between direct and indirect forms of participation. Furthermore, the case law of international criminal courts recognizes that the concept of participation as it relates to children must be interpreted more broadly to include indirect forms of participation that put children at risk. Another issue that remains largely unresolved is that both Article 38, paragraph 2 CRC and Article 1 OPAC require states parties to take only those measures that are feasible to fulfill their treaty obligations with respect to the participation of children in hostilities. The term feasible relativizes the standard of protection. It is much easier for states to declare a measure infeasible than to declare it unnecessary. Thus, the limitation to feasible measures means that the protection provided by the CRC and OPAC is considerably weaker than the standard under Article 4, paragraph 3 of Additional Protocol 2, where the prohibition on not involving children in hostilities is not contingent upon the feasibility of alternative measures. According to the ICRC study on the current state of international humanitarian law, Article 4, paragraph 3 of Additional Protocol 2 reflects customary international law. Against this background, it is to be welcomed that, despite the permissive wording of feasible measures, the CRC Committee endeavors to ensure that states parties fulfill their obligations in a manner consistent with the tenets of applicable international humanitarian law. Second, the provisions of the CRC on the recruitment of children into armed forces are not without flaws. Here too, however, a careful distinction must be made between Article 38 CRC and the corresponding provisions of OPAC. According to Article 38, paragraph 3 CRC, states parties shall refrain from enlisting in their armed forces any person who has not attained the age of 15. Although the norm mirrors the standard of international humanitarian law, the minimum age of 15 years again represents a deviation from the age threshold in Article 1 CRC. A more extensive and child-friendly protection was simply not achievable when the CRC was drafted. As with the participation of children in hostilities, the minimum age of 15, enshrined in Article 38, paragraph 3 CRC, has been raised to 18 in Article 2 OPAC. However, this strict age limit of 18 applies only to compulsory or enforced conscription, not to voluntary recruitment. With regard to the latter, Article 3 OPAC merely raises the minimum age to at least 16 years through national legislation of states parties and obligates states to comply with some fundamental safeguards. Recruitment must be genuinely voluntary, and admission to military service must require a prior proof of age. This compromise between the different legal cultures, which is evident in Article 3 OPAC, reflects the existing rules of international humanitarian law. Once more, it contravenes the object and purpose of the age limit in Article 1 CRC and the spirit of the Convention. However, OPAC shows improvements in other respects. the rather weak obligations in Article 38 CRC, which moreover mainly relate to the participation of children in national armed forces of states, have been expanded by OPAC. Article 4, paragraph 1 stipulates that non-state armed groups are prohibited from recruiting or using in hostilities persons under the age of 18 under any circumstance. In addition, Article 4, paragraph 2, OPAC obliges states parties to take all feasible measures to criminalize such practices. During the drafting of OPAC, it was acknowledged that non-state armed groups were not eligible to become parties to the protocol, and that it was therefore necessary to ensure that states were obliged to regulate their practices. Consequently, the CRC Committee rightly insists on the obligation of states parties to prosecute and punish members of non-state armed groups for the use and recruitment of children. International criminal courts generally follow this line. For example, the judgment of the Special Court for Sierra Leone against former President of Liberia, Charles Taylor, in 2012 was the first time that a former head of state was convicted of war crimes against children committed by an armed group not under his direct command and control. In a similar vein, the International Criminal Court convicted Thomas Lubanga Diallo, former president of the Union des Patriotes Congolais, for the war crimes of recruiting and using children in hostilities. In the case of Bosco Ntaganda, who was a subordinate of Lubanga Diallo and was found guilty of recruiting children and of rape and sexual slavery by subordinates of his militia against children under the age of 15 in the same militia, the ICC stressed that child soldiers do not lose the protection of international humanitarian law because of their illegal recruitment and use in hostilities. However, the situation is different when a commander who was forcibly conscripted during childhood commits crimes against humanity and war crimes in adulthood. In the case of Dominic Ongwen, former commander of the Ugandan Lord's Resistance Army, who was himself abducted into an armed group at the age of around 10 and committed multiple war crimes and crimes against humanity as an adult, including crimes against and affecting children, the ICC did not rely solely on Ongwen's own experiences of violence in childhood. Rather, the court carried out a comprehensive and complex balancing of individual guilt and collective injustice. The assumption of a dual status as both perpetrator and victim does not preclude criminal prosecution. Previous victimization does not justify or excuse subsequent victimization of others. In sum, these verdicts represent a significant development as they convey a clear message that child recruitment constitutes a war crime and that those who perpetrate violations against children will be held to account. However, a disadvantage is that the criminal offenses outlined in the statutes of the International Criminal Courts, including the ICC statute, continue to be based on the age of 15, a figure that does not reflect the increase in age provided for by OPAC. The discrepancy is particularly problematic given that OPAC now has 173 contracting parties, much more than the ICC statute. Third and finally, the protection provisions for children otherwise affected by armed conflict are not without deficiencies either. Article 38, paragraph 4 obligates states parties to take all feasible measures to comply with their obligations under international humanitarian law. In this respect, the norm is primarily applicable to children who are civilians, but it also extends to children associated with armed forces or armed groups. Key rules under international humanitarian law, which are designed for the protection of child civilians and to which Article 38, paragraph 4 refers, encompass the right to evacuate from besieged and encircled areas by establishing specific safety zones and secure localities for children, the right to care, welfare, and health care, in particular for children who are orphaned or separated from their families, the right to relief, schooling, education, playgrounds, protection from assault, and the provision of a safe cultural environment, the right to humane and child-appropriate treatment of arrested, detained, imprisoned, or interned children, and the exemption of the death penalty. In particular, the detention of children is to be employed only as a measure of last resort. If arrested, detained, or interred for reasons related to the armed conflict, children who are not accompanied by their families shall be held in quarters separate from those of adults. In all other cases, children should be accommodated as family units. In addition to these numerous individual provisions, Common Article 3 of the 4 Geneva Conventions establishes a minimum humanitarian standard applicable to all persons in both international and non-international armed conflict. The elementary considerations and the minimum yardstick of humanity include the absolute prohibition of war crimes against children. Nevertheless, the term feasible measures in Article 38, paragraph 4 of CRC once again results in a diminished level of protection offered by the CRC in comparison to the relevant provisions of international humanitarian law. The ICRC had already made it clear during the drafting of the CRC that all rights enshrined in the Geneva Conventions and their additional protocols that deal with the protection of children in the civilian population are worded more strictly than Article 38, paragraph 4 CRC on account of the problematic term feasible. In order to align with the Convention's overarching objective of attaining the highest possible standard of protection for children, the CRC Committee consistently employs a more vigorous language than feasible measures. It urges states parties to take every effort to protect children from the effects of armed conflict and to take effective or at least suitable measures in accordance with international humanitarian law. Moreover, the CRC Committee constantly recalls that all guarantees set forth in the CRC must be fundamentally respected even in the context of armed conflict. The Convention enumerates a comprehensive list of rights applicable to children and does not provide for a general derogation clause as it is established, for instance, in Article 4 ICCPR. Therefore, the rights granted to children in the CRC would have to apply at all times, including an armed conflict. In this regard, the CRC Committee not only demands compliance with the standards of international humanitarian law, but also highlights the responsibility of states parties in situations of armed conflict to safeguard children from gender-based violence and harmful practices, as well as from the adverse impact of business activities. It also expects states parties to ensure special protection for indigenous children and children affected by disease, to provide opportunities for play and recreation, to ensure access to social services and education, and to guarantee children's active role in peace-building and post-conflict resolution processes. The CRC Committee further underscores this comprehensive approach by generally refraining from distinguishing between categories of children in armed conflict. The committee maintains that child combatants and children belonging to armed and terrorist groups are also entitled to special protection as victims. With these demands, the CRC Committee exceeds the recognized standards of international humanitarian law. It is also questionable whether this broad interpretation can be reconciled with the text of the CRC and the methods of treaty interpretation recognized under international law. The International Court of Justice has repeatedly emphasized that the protections offered by human rights conventions do not cease in times of war. At the same time, however, it has pointed out that this principle is not an absolute one, but rather subject to limitations. These include instances where international humanitarian law is the applicable lex specialis, thereby displacing international human rights law. This leads to the conclusion that not every single human rights standard of the CRC, which is primarily designed for peacetime, can simply be applied to armed conflicts without further consideration. In conclusion, it is evident that Article 38 CRC, although initially hailed as an advancement when the CRC was drafted, ultimately represents a regression rather than a progression. A notable concern is the low minimum age set for the involvement of children in the armed forces or participation in hostilities, although it is consistent with international humanitarian law. The only instrument that has so far addressed this deficit and generally improved the protection of children in armed conflict is OPAC. As a legal instrument binding on 173 states, it is imperative that greater attention be given to its rules. Furthermore, it is of high value that the CRC committee has adopted OPAC's Trade 18 approach and routinely employs more robust terminology than feasible measures. The committee's general approach reflects its willingness to synthesize international humanitarian law and contribute to the solidification of international criminal law. At the same time, the committee demonstrates a capacity for dynamic, very dynamic adaptation, aligning the standards of the Convention with the object and purpose of the CRC. Yet the interdisciplinary CRC committee is not empowered to make legally binding decisions, which weakens its authority vis-à-vis other actors in international law. Additionally, the committee opinions, at least in my view, on occasion extend beyond the explicit wording of the Convention, rendering them not always legally sound. Nevertheless, the work of the CRC committee continues to be meaningful for a holistic protection of the child, particularly in the light of the numerous ongoing armed conflicts in which children are among the most affected victims. In this capacity, the committee serves as a global conscience of children's rights, demonstrating how the legal systems of international humanitarian law and international criminal law could be designed or interpreted in a manner that is more child-friendly than heretofore. In any case, there is no doubt that the fundamental moral premise of the child's rights movement, quote, "Mankind owes the child the best that it has to give," quote finish, retains its significance and urgency today, a century after it was first articulated in the preamble to the Geneva Declaration on the Rights of the Child. Thank you for your attention.